My name is Christopher Stock, and I'm an Employee Benefits and Executive Compensation Associate with Troutman Sanders in Richmond, Virginia. I want to welcome you to the initial podcast in a series of podcasts that Troutman Sanders and Pepper Hamilton will be producing over the next few weeks to discuss employee benefits and executive compensation, as well as labor and employment topics that employers have been confronting in light of the COVID-19 pandemic, as well as considerations for employers as they look to respond to those issues. On today's podcast, we will be discussing the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. The retirement plan provisions in the CARES Act offer qualified individuals favorable tax treatment for coronavirus-related distributions and greater flexibility on defined contribution plan loan limits and repayment terms. For purposes of the coronavirus-related distributions and special defined contribution plan loan rules, a qualified individual is a participant who is diagnosed or whose spouse or dependent is diagnosed with SARS-CoV-2 or COVID-19 by a CDC-approved test, or who experiences adverse financial consequences due to a coronavirus-related impact on employment. Coronavirus-related distributions are not subject to income tax withholding or the 10% penalty otherwise applicable to early distributions. In addition, a participant can recognize taxable income on a coronavirus-related distribution over a 3-year period and can receive rollover tax treatment by recontributing all or part of the coronavirus-related distribution to an eligible retirement plan or IRA within 3 years. Qualified individuals can take advantage of higher plan loan limits up to the lesser of $100,000 or 100% of their vested account balance instead of $50,000 or 50% of their vested account for loans made between March 27th and September 22nd, 2020. And for qualified individuals with outstanding loans, there's a 1-year delay on the due date of any loan repayment otherwise scheduled between March 27th and December 31st, 2020. In this podcast, we'll explore issues in the initial rollout of these measures. Topics include the extent to which plan administrators are accepting self-certification of qualified individual status and the form of content required. Money sources available in participant accounts for coronavirus-related distributions, amending plan documents and updating summary plan descriptions, communicating coronavirus-related distribution and plan loan rules to participants, and key open issues pending IRS guidance. Now that we've covered the background, Paul, let me ask you, does a qualified individual include a participant whose employment is not affected by the COVID-19 pandemic, but who experiences an adverse financial consequence because the employment of the participant's spouse is impacted?
Thank you, Chris, and great question on what is perhaps a gray area in the CARES Act definition of a qualified individual. So the CARES Act provides that a qualified individual includes an individual who experiences adverse financial consequences as a result of the individual's COVID-19 related quarantine, furlough, layoff, work reduction, work absence for child care for care of a child with COVID-19, closure or reduction of a business owned or operated by the individual, or, quote, other factors as determined by the Secretary of the Treasury. So, each of those criteria I just listed for qualified individual eligibility relates to the participant. That is, the furlough of the participant that's COVID-19 related, or layoff of a participant that's COVID-19 related, except for possibly the last criteria that I read, those other factors as determined by the Secretary of Treasury. So far, the IRS has not issued guidance expanding a participant's COVID-19 adverse financial consequences to include a similar adverse impact related to a spouse's employment. But apparently, the IRS has received a number of questions and comments on this very issue, and hopefully we'll see further guidance in the near future. Meanwhile, the forms that I've seen for a participant's self-certification of qualified individual status, which we'll talk about a bit more in a minute, do not include adverse financial consequences related to a COVID-19 impact on the employment of a participant spouse. Oh, and by the way, those self-certification forms don't have any reference to these other factors to be determined by the Secretary of Treasury. So I guess we'll wait and see on that one.
So, Paul, as you mentioned, the CARES Act allows eligible retirement plans to accept a participant's self-certification that they are a qualified individual for purposes of coronavirus-related distributions and special plan loan limits and repayment terms. Are plans generally accepting self-certifications? And what form and content have you seen for this?
Yes, Chris. All of the employers that I work with have authorized their plan record keepers to accept a participant's self-certification of qualified individual status. And my understanding is that record keepers, including the larger ones, are generally suggesting this approach. I would imagine that the reasons supporting self-certification include the ease and speed in processing distribution requests and avoiding the complications of a plan administrator otherwise evaluating and determining a participant's status as a qualified individual. Now, the self-certification forms that I've seen are very straightforward, very brief, and contain almost verbatim the wording from the CARES Act definition, with the notable exception of any reference to qualified individual status based on other factors to be determined by the Secretary of the Treasury, which we just spoke about. And yes, the self-certification forms that I've seen really do not go beyond the scope of the plain reading of the CARES Act definition. And by the way, the IRS has already pointed out in a guidance that followed the CARES Act that plan administrators may rely on self-certification unless, of course, the plan administrator has actual knowledge to the contrary. For example, if a participant self-certifies that they have an adverse financial impact due to their layoff, but the employer knows the participant has not been laid off, well, then they wouldn't accept the self-certification. But the IRS has further pointed out that while the plan administrators may rely on such self-certification, the individuals, the participants, may have to substantiate their qualified individual status for purposes of their own tax filing. And for this reason, the participants should retain any records or documents supporting their self-certification. For example, if, Chris, as you mentioned, qualified individual includes someone who was diagnosed with COVID-19. And if that's the basis for their self-certification of qualified individual status, they might want to hold on to those medical records in case the IRS wants some sort of backup. And similarly, if they were laid off or furloughed, they might want to keep some easily referenced records from their employer to that effect.
Thanks, Paul. On the topic of coronavirus-related distributions, are eligible retirement plans required to offer coronavirus-related distributions to participants?
Excellent question, Chris. And the short answer is no. Retirement plans are not required to offer coronavirus-related distributions. And this, of course, is very important for participants to know in case they read about these special tax rules in the newspaper or online and just assume that they're entitled to them. And then further, it's important for the employers to be aware of so that they know and affirmative steps are required for them to implement coronavirus distribution provisions if they choose to do so. So if an employer does not provide for coronavirus distributions under their plan, distributions to participants who have not terminated employment may be limited to hardship withdrawals or in-service withdrawals that are available to participants who have attained age 59 and a half, as well as distributions to participants who have terminated employment and would be subject to normal requirements for withholding and the 10% early distribution penalty if applicable. However, there is one note I'd like to add to that some practitioners have focused in on, and that is whether a participant may nevertheless be entitled to the special tax treatment offered under the CARES Act for coronavirus distributions, even if their employer plan did not have the provisions in place at the time the distribution took place. And this certainly could arise since coronavirus distributions may be eligible even if they were made prior to the effective date of the CARES Act. So we'll wait and see if there's further guidance on this from the IRS, and it may be the case that the IRS will allow individuals to receive the special tax treatment under the CARES Act for coronavirus distributions, even if those provisions were not in their employer's plan at the time that the distribution took place.
Are there any limitations on the money sources in eligible retirement plan accounts that are available for coronavirus-related distributions?
This question refers to the Internal Revenue Code's restrictions on the circumstances under which withdrawals can be taken from a participant's elective deferral account, such as through a hardship withdrawal, or from a participant's matching contribution account or profit sharing account, which of course would be comprised of employer contributions. Some plan administrators, as well as the record keepers, have wondered whether coronavirus distributions are subject to similar restrictions as hardship withdrawals or if special rules apply. The answer is that first, coronavirus distributions are distinguished from hardship withdrawals and other in-service withdrawals and distributions. It's a different type of distribution with its own set of rules, and the CARES Act does not indicate any limitations or restrictions on the money sources in a participant's account for coronavirus distributions. As a result, an eligible participant or qualified individual should be able to receive a coronavirus distribution from their entire vested account in elective deferral contributions, matching contributions, and other employer contributions. And by and large, the plan record keepers and third-party administrators that I've been in communication with have been reading this the same way and have implemented coronavirus distributions in this manner.
As you mentioned, some of the plan sponsors that you've spoken to, have they faced any issues in rolling out the coronavirus-related distributions?
Yes, certainly a number of issues, a number of questions arose with the employers at the time the CARES Act was enacted. The most urgent question when the CARES Act was signed into law was whether an employer would offer coronavirus distributions, which, as we've discussed, is not mandatory under the CARES Act. And then further, the employers wanted to know how they could implement it to make these distributions available as soon as possible when they're most needed. I found that the plan record keepers have been very responsive, particularly the larger record keepers and third-party administrators, in facilitating coronavirus distributions, preparing the necessary forms, distributing participant communications, and anticipating questions from participants and the employers. For the most part, Plans that offer coronavirus distributions have started processing already, and they will adopt the formal plan amendments later. And now that we're more than a month into the crisis, employers are starting to follow up on communications with both active and inactive participants, make sure that they're fully aware of the tax and other advantages of coronavirus distributions, and working with their record keepers on the tax reporting and plan documentation issues follow.
Thank you, Paul. Mamta, I'll ask you. As we mentioned earlier, the CARES Act increases the maximum loan limits for qualified individuals. Must retirement plans make loans under the higher limits available to qualified individuals?
Thanks, Chris. That's a great question. The short answer is no. That is, a retirement plan that does not already provide for participant loans is not required to add a loan feature to make loans available to qualified individuals under the higher limits provided by the CARES Act. In addition, if a retirement plan allows employees to take loans from their plan accounts, the plan can continue offering loans at the current loan limits, the lesser of $50,000 or 50% of the participant's vested account balance. Another point to note is that retirement plans typically limit the number of plan loans a participant may receive. This means that a qualified individual who has already taken the number of allowable loans from the plan may not necessarily be able to take another loan based on the higher limit, unless the limit on the number of loans is waived. An employer, however, is not required to waive any limit on the number of loans just so that a qualified individual can take advantage of the larger loan limit. To assist employees impacted by the COVID-19 pandemic, most employers I have been working with have expanded the loan feature under their plans to allow qualified individuals to take a plan loan based on the higher limits. However, in my experience, employers are not always waiving any limit on the number of plan loans a qualified individual may receive. As a result, a plan that, for example, provides a one loan limit and a qualified individual who already previously took a loan and has one outstanding will not be able to qualify for another loan under the higher limit.
So if an employer chooses to increase the limit on plan loans available to qualified individuals, can the plan apply a more restrictive definition of qualified individual than provided under the CARES Act?
Yes, Chris. As Paul mentioned earlier, under the CARES Act, a qualified individual includes a participant who or whose spouse or dependent is diagnosed with COVID-19 by a CDC-approved test, or a participant who experiences an adverse financial consequence due to a COVID-19 related quarantine, furlough, layoff, or reduction in hours, or is unable to work because of a lack of childcare due to COVID-19. Many retirement plans offer loans only to active employees, so that employees on a leave of absence or on layoff would not qualify for a loan. And the reason for that is because loan repayments are typically made through payroll deductions. For that same reason, employers who adopt the higher loan limits under the CARES Act may still decide not to permit the loan to any qualified individual whose employment has terminated, for example, by being laid off, or who has been placed on furlough and as a result may not be receiving compensation from which payroll deductions can be taken. I also want to point out that the definition of qualified individual applied for the coronavirus distribution does not have to be the same as the definition applied for purposes of the special loan provisions under the CARES Act. The definition of qualified individual provided under the CARES Act is expansive. An employer can be more restrictive, and the employer can impose a different definition for purposes of the coronavirus-related distribution, for the increased loan limits, or, as I'll discuss later, the delay in loan repayments.
On that same topic as the delay in loan repayments, are plans required to delay loan repayments that are otherwise due between March 27th and December 31st, 2020?
So there has been much confusion about whether the delay in loan repayments is mandatory or whether the employer can decide not to delay the repayments. The CARES Act provides that in the case of a qualified individual with a loan from a qualified employer plan that is outstanding on or after March 27th, the due date for any loan repayment with respect to such a loan that occurs during the period beginning March 27th and ending December 31st shall be delayed for 1 year. The Department of Labor and the IRS recently clarified that the loan delay provision is optional. An employer may choose not to provide for the delay. I also want to point out that employers I have been working with that have added the loan repayment delay to their plans still allow the affected participant to choose whether or not to delay their loan repayments. Because interest will continue to accrue during the period of the delay, resulting in larger loan repayments once they resume, some employers may want to allow participants to continue making loan repayments without any delay. So plan sponsors who are looking to implement the delay in loan repayments have a number of questions they need to address. One is whether they actually want to add the delay in loan repayments to their plan. And the second is if they do add it, whether they want to allow employees to basically opt out of it.
Thanks, Mamta. That was very helpful. As you mentioned, relief provided under the CARES Act for loan repayments due between March 27th and December 31st is limited to qualified individuals. Is any relief available to participants who are not qualified individuals?
So yes, Chris, when the CARES Act came out, the relief is limited to qualified individuals. But the IRS in Notice 2020-23 is providing temporary relief to all participants with planned loan repayments that are otherwise due on and after April 1, 2020 through July 14, 2020. The missed repayments can be made by July 15, 2020. Based on the guidance, it appears that unlike the loan delay under the CARES Act, no additional interest accrues under the IRS notice from the date the loan repayment was otherwise scheduled to be made to July 15. Due to the limited availability of the loan repayment delay under this IRS notice, plan sponsors who wish to make this relief available will need to act quickly and work with their record keepers to have the provision implemented in operation under their plan.
Thanks, Mamta. What issues are employers encountering as they implement the 1-year loan repayment delay?
A key issue for which IRS guidance is still needed is whether the 1-year delay in loan repayments also applies to a terminated employee, payment of whose entire outstanding loan balance is due in full following termination from employment during the period from March 27 to December 31, 2020. Whether or not the loan repayment delay provision applies will ultimately affect when the participant's loan may be defaulted if the participant is unable to timely repay the full loan. So, more guidance to come hopefully in the near future.
Thank you, Mamta. Now we'll transition to the timing of plan amendments and employee communications. Paul, I'll ask you. Must retirement plans that implement the coronavirus-related distribution and/or the special loan provisions under the CARES Act amend their plan by the end of this year?
Thanks, Chris. And the short answer to your question is no. Thankfully, the IRS has and the CARES Act provide some relief on this, although changes under the CARES Act may be implemented immediately, including what we've discussed, the coronavirus-related distributions and the special loan rules and limits. Nevertheless, plan sponsors will have until the last day of the first plan year beginning on or after January 1st, 2022 to adopt the necessary amendments to their plans that implement the procedures that they're adopting now. So, for example, a calendar year plan will have until December 31st, 2022 to formally adopt the required amendments. The deadline's a little bit different for governmental plans. It's the last day of the first plan year beginning on or after January 1st, 2024, so even longer. This, of course, is intended to give plan sponsors, the employers, the ability to provide these special distributions and loans right away prior to sorting out the precise language that will be required in their plan document. Not to mention, as we've indicated, we expect further guidance from the IRS later this year on some of the unanswered questions with respect to coronavirus-related distributions and loans. However, during the period that any of the new retirement plan provisions are implemented and before necessary amendments to the plan document and the loan procedures are adopted, plan sponsors should work with their third-party administrator or record keeper, as well as their legal counsel, to fully understand the changes that they're putting into effect now, such as who's a qualified individual or what definition they want to use for their purposes, and which group of participants will be allowed to repay the distribution plan. I guess more on that to come.
Thanks, Paul. Mamta, I'll ask you, are employers required to communicate to employees any changes adopted to their retirement plans for the CARES Act?
Well, that depends. If the retirement plan is an ADP ACP safe harbor plan, an updated safe harbor notice would need to be provided if the plan allows coronavirus distributions or the increase in the limit on loans. Otherwise, the employer must update the summary plan description for their plan or issue a summary of material modifications that describes the changes. However, the updated SPD or the SMM is not required to be provided to eligible employees until 210 days after the date the plan is amended to reflect the changes, which, based on the plan amendment deadlines, if the employer takes advantage of delaying adopting the amendments until the latest permissible date, could potentially, for some employers, be into 2023. Considering that the retirement plan relief under the CARES Act is for a limited duration, it is best practice for employers to communicate the changes now so that employees can take advantage of the relief. And that's what we have been seeing employers do. They've been working with their record keepers, their legal counsel, to make sure that communications go out to employees, letting them know of the relief available and being implemented under the plans so that they can take advantage of it when they most need it.
Thank you very much, Mamta and Paul, for joining me today to discuss these extremely important topics. And thank you to our listeners. For more information on the topics we discussed today or other topics related to the CARES Act or COVID-19, please visit the Pepper Hamilton Troutman Sanders COVID-19 Resource Center, available at covid19.troutman.com. And of course, if we can help you navigate any of the topics we discussed today, please do not hesitate to contact any one of us. Again, this is the first in a series of podcasts that Troutman Sanders and Pepper Hamilton will be producing over the next few weeks to discuss employee benefits, executive compensation, and labor and employment topics. You can also subscribe and listen to other Troutman Sanders and Pepper Hamilton podcasts wherever you regularly listen to your podcasts. including on Apple, Google, and Spotify. Thank you again for listening, and stay safe.
These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Sanders does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal and other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Sanders.